Good afternoon. I'm Angelica Spanos, and this is the Law and Crime Report, where we are diving into true crime and all legal stories making headlines today. First up, topping our newscast, the latest out of Idaho, where jury trials for Chad and Lori Daybell will now be combined. This is after a ruling was made. You'll recall that the Daybells are allegedly behind the deaths of 7-year-old J.J. Vallow and 16-year-old Tylee Ryan. The siblings' bodies were discovered at Chad Daybell's property after a 6-month investigation. Tylee was Lori's daughter from a former marriage, as well as her adopted son. Now, the children were first reported missing in August of 2019, and after that, the stories that the Daybells were telling all started to unravel. The pair got married in Idaho as a nationwide search for the kids was underway. The couple then was found in Hawaii, where Lori was later arrested and extradited back to Idaho. Then in June, the children's remains were found on Chad's property and he was arrested. A motion was filed to join their cases because they participated in the same acts, according to prosecutors. The state's arguing that holding separate hearings would create an undue burden on the state by requiring repetitive work and multiple hearings. Chad Daybell's attorney is opposing this. He's arguing that a joint trial would be prejudicial. Let's listen.
I think in good faith, I can't argue that the allegations, and I want to make it clear that they are allegations, against Mr. Daybell and Ms. Vallow are similar in nature, and that under the prong of 8B, it applies, and the joinder does apply. The objection, Judge, that I file talks about prejudice. Further, I appreciate that Mr. Wood recognizes that at any time in the future, I can file a motion for severance under 14 and say that trying these two folks in the same proceeding is highly prejudicial. Mr. Wood and I have discussed, and I'm not going to make a matter of this, but there's still some housekeeping that needs to be done in terms of discovery that Mr. Wood and I are going to privately engage in trying to resolve, and if necessary, we'll ask the court's assistance. But at this point, without all of the information in this case, I'm not in a position to argue severance on this date, and that's going to have to be reserved for a different date. But Mr. Wood's argument, Judge, to suggest convenience to the court and expense to the county and the difficulty of witnesses is secondary. And primarily, Judge, the importance is Mr. Daybell going to get a fair opportunity to present his side of the story? And is it going to be able to be presented without any kind of prejudice or bias? Or are they going to infer anything from any other witness or any other defendant or anybody else that does not afford him an opportunity to fairly present his case? And although 8A doesn't specifically address bias, the Nava case talks briefly that there is still a prejudice or a bias, and the court can evaluate that. Now, I understand there's been an inordinate amount of publicity. Mr. Wood has pointed out examples of some of the publicity, and I've pointed out examples, and that's going to be reserved for a different date in November when we talk about venue. But the fact remains, Judge, that by linking the two of these folks together is still going to provide a modicum of prejudice. And although I have to concede that joinder, when you look straight at the rule 8A, that there is an allegation of similar facts in this case. The fact remains is what I would ask the court to do is reserve a ruling on joinder, allow the argument to be made in terms of severance once Mr. Wood and I have resolved our discovery issues, and decide at that point whether or not we're going to proceed in a common trial. I don't think it's an effective argument for Mr. Wood to suggest that he's going to have to make more effort and he's going to have to do duplicative work in two different cases. And I'm sorry that he's going to have to engage in that.
All right, so we're hearing that the Daybells trials will be combined now. Joining us today to break this all down, we have Bob Hill, a trial attorney with us, as well as Gigi Gonzalez, criminal defense attorney. Thank you both for joining us today. Let's talk about this because this is obviously a big story. This is a story that everyone was following over the summer when it all unfolded and broke. And this trial is going to be having a lot of media coverage. So, you know, based on what's been said about this by the lawyers, we know, listening to Daybell's attorney here, he says that this coverage that it's going to get is going to make it hard for Daybell to get a fair trial in Eastern Idaho, because it's going to give the jury a stronger, more prejudicial opinion about him, rather than looking at the facts. Bob, coming out to you first, do you agree with that?
Well, first, he does concede that the judge has the right to combine these cases because they're related. The second thing is he says basically it's not the bias from the coverage necessarily itself, but the combined bias with trying the defendants together. But he offers nothing to establish what that bias is. And again, it's a weighing analysis the court has to do. And without really evidence of what that impact is, any criminal trial that has publicity is going to have that built-in bias. Where are you going to try this case, or how? So, I think there's a lot there that he needs to supply to the court before the court can be comfortable in taking the action that they want him to take.
And Gigi, as a criminal defense attorney, would you do the same thing? Would you fight for the same thing here?
Yes, absolutely. You want to be tried on your own merits, right? I think that with Chad Daybell, it would benefit him to be tried separate from Lori. At the end of the day, these are Lori's children that were found deceased, and to be tied to a mother who's being accused of destruction of evidence in regards to her children's remains is not a good look. And not only that, by trying the two separately, each of them has someone to pin the crimes on the other. So I would definitely agree with Chad Daybell's attorney to try to separate these cases as much as possible.
All right. And we know that Lori Daybell's attorney had no objection to the motion, which is interesting, Gigi.
Yes, it is. I mean, I think it benefits Lori to have someone sitting next to her, and that someone is the person who the remains were found on their property. And not only that, it's looking like Chad Daybell was potentially the leader of this cult that was overtaking people's motives. So she would be able to point to Chad to say that he's the one that did it, the kids were getting in the way, what have you. It's definitely someone that she can pin the crimes on, and therefore it's great for Lori to have him sitting next to her.
All right, thanks, Gigi. Let's listen to the judge deciding to actually try the cases together.
It's pretty clear that the first prong of whether or not there's a common scheme or plan is supported under Rule 8B for joinder of the offenses in this case. And then looking at whether or not the joint trial of the two defendants would be prejudicial, there was an allegation in the response that was filed that this would create additional publicity, which would prejudice the right of Mr. Daybell to a fair trial if these cases were joined. I've considered that. I've also considered the arguments of the state that having two separate courses run in two different cases with two different judges could result in separate evidentiary rulings. There could be some inconsistencies. There would be duplicative hearings. And I think quite concerning given our circumstances right now under our COVID restrictions and the difficulties we have even getting a jury trial at this point. The prospect of having two separate trials where two separate juries would have to be impaneled to try each case is concerning as well. And so when I look at all the factors and the supporting case law, I don't find that the prejudice at this point has been demonstrated that would be sufficient to prevent me from joining these cases. And so based on the analysis and consideration of the citations also provided by Mr. Wood, and also in due consideration of the new case that was cited by Mr. Pryor, the Nava case, I read through that as well. I do find the facts of that somewhat inapplicable to the issue I've got at hand. That's where a single defendant had a trial involving separate multiple victims, which were put together in a single trial. Here we've got two defendants with a single common scheme or plan that is alleged. And so upon consideration of all that, counsel, I am going to grant the motion to join at this time. As the parties indicated, that doesn't forego the possibility of a future motion for severance if
prejudice is demonstrated by the defense in support of that motion.
All right, so that's Judge Stephen Boyce there saying that he has decided to join these trials. However, we could potentially expect Chad Daybell to file to sever them again. Bob, is that something that could likely happen, do you think?
Sure. Counsel talked about discovery earlier, and we don't know what kind of statements are going to be used. So, for instance, if one defendant implicates another in a statement, there has to be those have to be eliminated from the evidence at some point if there's exculpatory or things that would excuse conduct in a statement of another. Those things all play into whether or not it would require separate trials. The other thing that was interesting, she had two trials scheduled, Lori Daybell. On the one was on the obstruction counts, and the other one was, of course, on the concealment, which is what Chad is charged with. So why those two didn't get combined in a separate trial if they're going to try both of those, or are they really, bringing all three trials together? They really didn't make that clear. But yes, I think that it's likely there's going to be another attempt to sever. But again, there was no demonstration of prejudice, as I noted before, and I think the judge is going to need that before he does anything differently.
Right, and we also know that both of the defendants have motions out there for a change of venue. Gigi, how's that going to play in here? That's also huge because one of the things they're saying is this area is small, and they don't believe that these two could get a fair trial in that part of Idaho.
Well, they're going to have trouble getting a fair trial in any part of Idaho based on what they're alleging. Idaho is a pretty small community, and this case has received international coverage. And it's going to be hard to find any juror that hasn't heard about this case. So I don't think that they're going to be successful in their pursuit to change venue.
And when you're looking at this, do you think that two different trials would be better here, or are you kind of on board with them being connected? Does two different mean there could be two different verdicts? What are your thoughts here, Gigi?
Well, when you try them separately, of course, there's a chance of two different verdicts. I think that for Lori, it's better to have Chad tried with her, and for Chad, it's better to have his own trial, and it just depends on whether or not I think the more likely person to move to sever is going to be Chad, and it's whether or not he can demonstrate the impact of prejudice present in order to get that granted. And if they are tried together, which is the most likely event, then most likely they're going to be, the verdict is going to be rendered similarly in both of their cases.
All right, and Bob, I'll just have you weigh in on that.
Well, I agree with Gigi on that. And I think, we don't know what the prosecutor or how they're going to present this case, but it sounds like they're going to want it definitely together. If I'm Chad, I don't want it together. I agree with Gigi because for Lori Daybell, having him there deflects from her, and it also makes this more a crime of obsession and control rather than focusing just on her as a mother whose children are dead and she tried to hide the evidence.
All right, Bob, Gigi, thank you both so much. We're going to take a quick break right now on Law and Crime. Plenty more headlines after this. And welcome back to Law and Crime. New today, a request from Breonna Taylor's mother is out. She's asking the charges in her daughter's death be considered by a new prosecutor. This is as grand jurors say that they were denied evidence. Two grand jurors came out anonymously and said that the prosecutors were dismissive of their questions and that there was an uproar when jurors realized that the police officers wouldn't be charged with Taylor's death. This is a complicated story that many of you have been following since it started. Our Law and Crime, Aaron Keller, has a breakdown of all the nuts and bolts.
Tamika Palmer says in a 109-page request that a competent and capable prosecutor willing to handle the case involving the officers who shot and killed her daughter should be appointed by a Kentucky office known as the Prosecutor's Advisory Council. Palmer calls her request nerve-wracking, but says someone other than State Attorney General Daniel Cameron must review the case. Here's how she described her own interactions with the AG. Following the proceedings, Attorney General Daniel Cameron had me drive nearly an hour to his office in Frankfurt, where he proceeded to tell me that his prosecution team was only able to obtain an indictment against LMPD officer Brett Hankinson. The Attorney General advised me that the grand jury declined to indict other officers and that his team had done the best they could. AG Cameron and one of his prosecutors then advised me that I should consider finding peace through the Lord, and watched as I sobbed uncontrollably. Palmer described having to pull off the highway on her way home because she was sick over what was said. Meanwhile, Cameron was telling the press that the grand jury determined the shooting was justified. He announced to a worldwide audience that his prosecutors walked the grand jury through every homicide offense, that the grand jury applied the facts to the law, and that the grand jury, upon reviewing the evidence, determined that the officers were justified in killing Breonna. These statements were flat-out lies, Palmer's document says. This is Aaron Keller for the Law&Crime Network.
All right, our guests with us today to talk about this, Bob Hilla and Gigi Gonzalez. Bob, I'll come to you first. First off, just your reaction to hearing about this. You know, we mentioned over the break how there seems to be new information about this coming out every week, every day. We're getting new things are surrounded Breonna Taylor's death.
Well, this issue right now is really the issue of prosecutorial discretion against integrity in the system. And, unfortunately, this happens on a daily basis, often in cases that don't have the media attention on it. But what's troubling here, I think, are the conflicting stories and the concern that some of the grand jurors had in the court. And I think that the important thing here is to maintain the integrity in this system, and a redo is probably warranted here to get that integrity and have a new grand jury with a new prosecutor look at it. And there's nothing prohibiting that. It happens all the time. You can have superseding indictments. You can have a no bill from one grand jury and then bring it back and represent it again. So there's nothing at this stage of the game where you have to worry about double jeopardy or anything like that. And I think to maintain the integrity and the trust in the system, they're going to really need to redo this case again, unfortunately.
Interesting. All right. And Gigi, Bob, basically saying there is a chance that these charges get looked at by a new prosecution. Do you agree?
Oh, yes, absolutely. Especially when we consider Attorney General Daniel Cameron's statements to the public that completely contradict the experiences of the grand jurors. He's going out here telling the public that he presented every charge of homicide available and that they presented all the evidence that they had, and the grand jurors are the ones that came up with it, to the fact that he looked Tamika Palmer in the face and told her that same lie. Bob Hill nailed it on the head. What's at jeopardy here, besides justice for Breonna Taylor, is integrity and trust in the system. And when you have someone who took an oath to protect the people and to uphold the law, flat out lying to victims, flat out lying to the public about his handling of the case, it jeopardizes that. And it jeopardizes people's trust in the system. So not only is it vital to, to gather a new grand jury and to present all of the evidence, truly present all of the evidence in this case, but to also replace Attorney General Daniel Cameron in the Breonna Taylor case.
So thinking about the mom here and her mom, obviously asking for a new prosecutor to handle this, does she have any other options on the table here, Gigi?
Does she have any other options available to her? I mean, she's kind of at the mercy of the laws presented, and the laws here are protecting officers, right? There are so many, between immunity for officers when they're acting in the course of their employment, and then you have an attorney general who's protecting every action of these police officers. It really seems like Tamika Palmer only has, the media and herself to advocate on behalf of Breonna Taylor, and using the media to hold the attorney general accountable for his mishandling of this case.
All right, Gigi, Bob, thank you. Another part of this case coming out, one of the officers that was involved in the raid that led to Taylor's death is now countersuing Breonna Taylor's boyfriend. Sergeant Jonathan Mattingly filed a civil suit against Kenneth Walker for emotional distress, assault, and battery on the night that she was killed. The lawsuit claims that Mattingly experienced severe trauma, mental anguish, and emotional distress. This is something that also unfolded here. Bob, what do you think when you heard about this new lawsuit here?
Well, it's not necessarily surprising where you have an officer, for instance, who's shot. I mean, very frequently we hear when there's a victim who's shot, that victim will sue. And we don't even know, the status, obviously, of the Taylor family in the claims that they're either made or will make. But basically, it's a civil action. Obviously, with respect to his injury, he would be entitled to personal compensation. But it's going to be a tough case because he's going to have to prove not only with the stand your ground law, because that could confer immunity here. And that's going to be an interesting issue, I think, in this case. It was in the apartment. There is a lot of dispute about whether or not the police officers identified themselves and whether this individual was in fear for his life. Also, Ms. Taylor had no criminal background or anything to suspect other than whatever the warrant was based on to go in there. So I think, it's a civil matter. It's going to run its course. It's going to be interesting to see whether he can establish, he doesn't even have to establish self-defense, whether the stand your ground law is eventually going to knock this case out.
Absolutely, and there was conflicting stories about where the gun was pointed, and as you said, just what happened inside is still sort of unclear. Gigi, why would the police officer do this? What's the point of that? And what does a judge say about this?
Well, the police officer probably feels that he has a claim. I would argue that his claim is frivolous. I think that the same law that provided Kenneth Walker with immunity for criminal charges in this matter also protect him civilly. And, I can't help but, in Walker's motion, he says that the shooting was outrageous, intolerable, and offends all accepted standards of decency and morality. I find that really funny because you know what? His actions that night were outrageous. In fact, the police officer's actions were so outrageous that it sparked legislative change. That's how outrageous their actions were. So for him to go to a court of law and try to assert this, I think a judge is going to look at it very disfavorably. And I believe that Kenneth Walker is going to walk out with yet another win, despite being further victimized by the police officers here.
And going forward, what's a timeline on something like this? This just happened. So would this being a civil suit unfold soon?
I'm not sure that it would unfold soon. My experience with civil cases is that they don't unfold very fast. I imagine that Kenneth Walker's attorneys are going to file for a motion to dismiss within the next few months, and then the judge will make a ruling. And if it is not dismissed, then there's going to be a lengthy discovery process. So it may take some time for us to see the results of this civil case.
All right, Gigi Gonzalez and Bob Hilla, thank you so much. We're going to take a break right now on Law and Crime. When we come back, more headlines and today's top stories after this. And welcome back to Law and Crime. We're talking now about the man convicted of killing Chicago Police Commander Paul Bauer. He was sentenced to life in prison with no possibility of parole on Wednesday. Back in 2018, Shamari Leggetti shot Bauer several times after a confrontation in a stairwell in a government building. Leggetti's defense attorneys pushed for a new trial, but his motion was denied and the court went straight to sentencing. Law and Crime's Aaron Keller has more on this story.
Shamari Leggetti entered court for a final time as a judge prepared to hand down his sentence. Investigators say Leggetti was dressed in body armor and was holding a gun with an extended magazine as he gunned down Commander Bauer in a stairwell in February of 2018. Police officers worked to capture a suspect for killing one of their own.
A man who viciously murdered a Chicago police officer was convicted on all accounts. Here was a man who had devoted his entire life to his family and the city of Chicago, and he was taken from us far too soon.
The late commander's widow and daughter spoke about Bauer's life, how he loved to read and cared deeply for his family.
We'll never stop mourning the loss but we're delighted that there was justice today.
A jury convicted Ligeti of 6 charges, including first-degree murder of a law enforcement officer. A defense motion for a new trial was denied.
It is the sentence of this court that the defendant, Shamari Ligeti, shall serve life in prison without the possibility of parole.
This is Brian Buckmeyer for the Law and Crime Network.
And background on that story from Brian Buckmeyer. We're going to intro our guests right now. Bob Hilla with us, trial attorney, as well as Gigi Gonzalez, criminal defense attorney. Bob, coming out to you first. Talk about your reaction to this verdict. Surprised?
No. I think, the circumstances of this made it a terrible crime. I think ultimately in the penalty phase, the individual that was killed came across as a wonderful person and a good cop. It was ordinarily the kind of a case that would have been a death penalty case, except that the death penalty was repealed in Illinois in 2011. So, he got life without parole. And, under the law, that's the limit of justice that could have been served here.
All right. And Gigi, we're talking about justice being served here. What are your thoughts on this case?
This defendant, Ligeti, he was arrested, he was tried, and he was convicted, and at the end of the day, that's what we trust the system to do, right? To try defendants as fairly as possible. And if a jury of our peers convicts him, then so be it. And obviously, in this case, the evidence was overwhelming to support a verdict of guilty. And I think that justice was applied here.
And is there a chance for an appeal here going forward at all?
I'm not sure. The defendant did move for a new trial. To be honest, I'm not sure what grounds he was stating the motion on. And later, because it was denied, they will appeal that, and the appellate court will make a decision as to whether or not, the trial court erred in not granting the motion for a new trial.
And during the trial, we heard victim impact statements. We heard from Bauer's family members, as well as hearing from Ligeti himself. Now, one of the interesting things about this is Ligeti did address the court, and many people thought or even expected that he would offer an apology, but he didn't. React to that, Bob.
Well, you have a defendant that's unrepentant. You're going to ask really to get the book thrown at you, and that's what happened in this case. There was absolutely nothing that expressed any remorse or redemption. And again, remember, this is the penalty phase. So there's been a conviction. There's been a finding by a jury that that a crime was committed and this defendant committed the crime. So those issues now before the court after that conviction are to convince the court that something other than the maximum which he received here would have served justice better. And the defendant gave the court nothing to base such action on.
All right, Bob, Gigi, thank you. Let's listen to the Cook County State's Attorney who announces the outcome of the sentencing in that courtroom.
Obviously, we are very pleased with today's verdict. It was a right and just verdict given the facts, the evidence, and the law. And while we celebrate the verdict, it is obviously an incredibly somber day for the people of the city of Chicago and the horrific loss of Commander Bauer in this senseless act of violence. We stand with our brothers and sisters in law enforcement and continuing to offer our support for the tireless work that they do, as evidenced by the fact that they literally put their lives on the line on behalf of the people of Chicago every day. This verdict is a reminder of the grave work that they do and the importance of that work. I'm proud of the men and women, the Chicago Police Department, for their professionalism and their dedication.
All right, so you hear the state's attorney there saying that justice is served. Beyond this, obviously the conviction, being the justice here, where does this go? Do you think race played a factor in this at all, Gigi?
I'm not sure. Even though the defendant, thinks it did, that's what his letter alluded to, that, defendants of his race are treated like thugs and animals versus defendants who have committed similar acts but are not Black are treated, fairly and as if they're innocent until they're proven guilty. I think the defendant truly believes that. But at the end of the day, this is a defendant who killed somebody in cold blood and was convicted based on that fact. So at the end of the day, I don't think race played a major factor here.
All right. And Bob, looking at this case, it's really different and almost opposite of when we were just speaking about Breonna Taylor's case. In this case, we have an officer who was shot and justice has been served. In the other case, it's the other way around. An officer shot someone and that person was killed and people are outraged about that. So looking at these two next to each other, what are your thoughts on that, Bob?
Well, there's no question that the social justice issue is out there and that, people of color get different treatment under the system than people who aren't in those communities of color. That's out there. That's the big debate that's on right now. I think what the prosecutor did here, because this crime really was not within the pale of that type of conflict, a case that you wouldn't look at and say this underscores that social justice issue. And I think she drew on the facts of this case effectively to help try and diffuse, some of that social justice challenge in this context by saying, this was a good cop, this was a good person, and this is someone who had a tough job to do and did it and died in the line of duty, and we need to remember that. So I think the prosecutor helped to balance that argument a little bit, but that argument is there. It's not going to go away, and it needs to be addressed in a bigger question within the system. And I think, part of it in the charging process, of course, is in the Taylor case that we talked about. But then there are other aspects in the process that are also under challenge here as well.
Absolutely. And, we have so many headlines about police brutality. And, you see a case like this where justice was served. The officer was killed really for no apparent reason. And then you have, the other side of this as well. How do people kind of form their opinions and separate these two type of instances into one? That seems to be the challenge right now. And as you said, socially, just a really hot button topic right now, too.
Those beliefs and those feelings are going to be based on people's experiences. And, where they have different experiences, they're going to have different opinions on it. I don't know that there's any right or wrong answer to this, but it is an issue and it's a problem that we need to address or we're never going to get past it.
Right. Gigi, what do you think about that?
I agree with Bob Hill. I think that the social injustices that we have here where, different defendants of different races are treated differently or people, of color are being policed differently. I think there's a lot to address here. And, we have to address that. We have to resolve those issues before we can really answer the types of questions like, if race played a factor in this matter, and because the social justice issues are so entwined with each other, it's hard to separate them. Where in this case, to me, it doesn't feel like race was a motivating factor in the killing. But to deny that there are police brutality cases based on race, it's this balancing act of which one is resolved first, and it's got to be the social justice issues.
Absolutely, and really, as a resolution to all of this, that's the toughest answer, right? That's the toughest thing to come up with. We're not sure how to go about resolving these types of issues.
Well, we can start by reforming policing, right? We could start by having different agencies handling different types of problems. Right now, we have a police force that is equipped to handle everything from mental health issues to armed robberies to murders. I mean, that's a lot to ask of one department. I think that we would be better serving the community and the police agency by having these separate agencies, having mental health professionals addressing mental health issues, having the police address actual criminal activity versus social disturbances. I think by going in that route of mindful policing and community policing, we begin to resolve those issues.
Gigi Gonzalez and Bob Hilla, excellent insight as always. We're taking a break right now on Law and Crime. When we come back, more headlines after this. And welcome back to Law and Crime. Switching gears right now over to the NYPD police officer who allegedly murdered his autistic son. Well, he has resigned to protect his pension. The murder case against Michael Valva in the death of his 8-year-old son is ongoing, but his career as a cop is over. The NYPD offered him a resignation without disciplinary hearing, and that allowed him to not admit any culpability and just resign, which all allowed him to keep his pension. He will get no salary, though. Valva is charged with his fiancée, Angela Polina. They allegedly threw the boy into a freezing garage in January when the temperature was 19 degrees. He was forced to sleep there. He died of hypothermia. Valva told authorities that he had fallen in the driveway while waiting for a school bus and then lost consciousness. Attorneys said that they're looking for separate trials for the defendants here because the co-defendants' approaches would clash with each other. He's now working on suppressing a number of Valva's statements that were made, also recordings that were discovered that showed that both of them, the couple, knew that the child was suffering. Valva was a 15-year department veteran. He is now suspended from the NYPD without pay since that January arrest. This is a pretty horrific and tragic story here. Bob Hilla and Gigi Gonzalez with us. Bob, first question I have, of course, is if he is guilty of this and is found guilty, does he still get that pension?
And again, I would guess from the way the deal was structured that he would still get it, knowing that these charges were hanging over his head. They wouldn't have worked this deal. But again, this has nothing to do with the criminal justice system. This has everything to do with a collective bargaining agreement between the department and the city. And what the terms of that agreement say. And so, they worked a deal on that. The department probably didn't want to have some sort of a loosely held proceeding that could undermine or perhaps hurt or give him an opportunity to do discovery by getting testimony at a departmental hearing when they want to go to court on this. So I don't believe that he would lose that even with a conviction.
And you mentioned this over the break, but New York, obviously a no death penalty state here.
New York has no death penalty. He would qualify, and this is a terrible, terrible, terrible case. You could title this cruelty, torture, and death with what happened to this child. Second degree, he recklessly killed someone under 11 years old with a depraved indifference to human life. Certainly that qualifies. And first degree would be intent to kill and under torture and cruelty. And I think that certainly the statements from his very own lips are going to be very important if they come into this case. But if you accept those statements and what they were saying about what happened at the time, that would have qualified for first degree. And in 2004, New York really in case law abolished the death penalty after Governor Pataki had signed legislation that put it back by lethal injection, and legislative attempts since 2004 have been unsuccessful. So New York does not have a death penalty law, and he would be looking at probably 15 to 25 years for second degree and 20 to 25 years to life without parole for first degree.
All right. And Gigi, let's get over to you about this in about a minute. What are your reactions to this? All right, it looks like we do not have Gigi's signal right now. Bob, one of the things we spoke about earlier in this hour was the idea of these separate trials for the Daybells, the Idaho couple. This is kind of something similar. We're talking about separate trials here. Volva's attorney, I believe, wants to be trialed solely, whereas there's a co-defendant here, his fiance. So is this an instance where these two could get coupled together as a single trial as well?
Sure, they can. Generally, if the facts that form the basis of the criminal conduct and the defendants having committed that conduct are the same and can form one indictment, would all be able to fit in one indictment, that those individuals can be tried together. It would only be with respect to whether there was any prejudice, and they would have to demonstrate that. The Sixth Amendment guarantees a public trial and a speedy trial and an impartial, doesn't say fair jury, but that's been construed obviously, but impartial jury. So, but it doesn't say that defendants have a right to be tried separately. And that's a rule of procedure to ensure that there's no spillover for one that unfairly impacts and creates a conviction, for the other. Generally, the way the courts deal with that is they look at statements that are going to be introduced where those statements may impact the other party. And then the federal law says that there are certain safeguards you have to impose there, and maybe then have a separate trial. So that's just a general summary of how the courts approach that.
All right, thanks, Bob. We want to get in one more story before the end of the hour here. DNA is now linking a dead man to a cold case murder all the way back from 1974. The case is now solved decades later. Siobhan McGinnis's disappearance haunted a small town in Montana. The 5-year-old girl was abducted and stabbed to death and left in a drain culvert. Well, now authorities say that it was a man passing through the town. His name is Richard William Davis. He died in 2012 at 70 years old. But this discovery is now finally bringing some closure to her family. Bob, this is a big topic of new conversation here about this DNA and how the technology has such evolved that they're able to now solve these old cold cases. Do you think it's time we just start doing this with all cold cases?
Well, I think you're going to see two things. Number one, obviously collecting the individual defendant's DNA to try and prove a case, but then you're also now going through genealogy records as a second step to try and identify a defendant from a DNA on old evidence, because the techniques have gotten so good. And to counterbalance that, you do have like the Innocence Projects and things that are seeking to acquit people too, as well as that, and also to challenge the integrity of the collection process and the introduction of the DNA and evidence in a trial. So we're making great strides, and I think you're going to see a lot more crimes from the past solved if that type of evidence is available.
It's truly incredible. And, for her family, this is obviously a bit of closure they're finally getting.
Yes, it is. And the sad thing about this case, unfortunately, is they are getting closure, but no justice for this little girl. But again, at this point in time, it's not going to bring her back, but it will be able to maybe close the book for them and be able to, for them to move on.
Right. And hopefully this instance, obviously, as we said, maybe sets an example for all these groups and people that are trying to go back to these cold cases and solve them with the new technology, with all the advances that have been made from the DNA, that they are allowed to grab from these old crimes. It's really, as we said, just moving along, and a lot of the advances are obviously helping to solve these old cold cases. We are done here on the Law and Crime Report. Bob Hilla, thank you so much, as well as Gigi Gonzalez. Thank you for being on the show today. Coming up, we have more of our regular scheduled programming. Thanks for being here.